Good morning, everyone. I welcome you all to this mini workshop, and I hope you all are keeping safe and healthy. And now, without much further ado, I'll walk you through our agenda for the session. So, me and Henry would be your presenters for this session, and we would discuss a lot of practical aspects related to your AI innovations and what are the some of the practical tips that you can use. So we start with an introduction of AI as a field and what are the components and challenges. Then we also discuss briefly about eligibility, like does your work warrant patent protection? Then we move on to the specific challenges and practical tips that we can use to overcome these. Then we briefly outline the filing and subsequent processes for patent drafting and filing processes. And we also discuss some of the government incentives and schemes in that section. And finally, we leave the stage open if time permits for some questions. So you all are aware that AI, artificial intelligence, is an emerging field, and Neha has also briefly touched upon what are the trends in this field. So when machines try to simulate human intelligence, so that is what artificial intelligence is all about. There are a lot of enabling technologies in this field. Some of these include speech processing and which includes natural language processing. We have image analysis and computer vision. Then some of the key enablers include a learning methodology and learning model and training data sets which are used to provide intelligence. Now, AI inventions can broadly be defined to have three major parts. The first part is a training aspect, second is a model, and third is an application. Now, by their very nature, because of having these three different parts, AI inventions become a little tricky to patent, and why we would see in subsequent slides. But just to have an idea of how somebody who is a practitioner or who is drafting patents sees AI inventions, so training is based on a large set of training data, and the training is mostly done in offline setup. And then the next stage comes modeling, which is the actually learning implementation. In model generation and learning, there are prediction methodologies. There is your actual algorithm, which is a sequence of computer programs, instructions, complex mathematical and statistical functions. Then there is analysis of inputs, and based on those, a model is trained on the data and it develops learning strategies, which could be of supervised learning, unsupervised learning, reinforcement learning, or semi supervised. And based on all of these, the model generates an outcome. So, the outcome of the model is related to the real world application, something that we are able to see as a tangible output. And this outcome could be in any form. It could be in the form of a control operation. For example, you want to control a robotic arm. It could be in the form of advanced analysis. It could be used in some business processes for further data analytics, trends prediction. Then this outcome could also be in the form of some verifications or user notifications. For example, if we talk about some navigation applications, then based on learning based models, some notifications for driving control could be generated. So these applications tie the training and model aspects to the real world scenarios which the model is actually designed for. Then why are these inventions tricky to patent? That we will see along with who all can get a patent on their work. So if you are a startup who is developing a new technical product that relates to AI, or you can be an individual inventor researching and devising new methodologies. You could be devising a novel process for training, or you could be a large or big firm or corporate who has a continuous process of ideation, and development of AI-based products and processes. And you could have a competitive strategy wherein you want to get ahead of your competition by focusing on AI domain. And as a result, you are developing products, processes, and want to get into the field of AI. Or you could be thinking of a litigation strategy, or you could be defending an ongoing lawsuit. So, if any of these scenarios fit the bill, they seem suitable, so you should go ahead and get a patent. Now, Indian patent law actually describes an application for a patent can be filed by anybody who is a true and first inventor, or is the true and first inventor's assignee, or is a legal representative of the deceased true and first inventor or his or her assignee. So that means individuals, startups, small, medium, large entities, Fortune 500 firms, R&D centers, anybody can file a patent. And when do you go for patenting strategy? So, like whenever you have developed something based on your R&D, some litigation has come up, you are defending your competition, or is it part of your strategical move? So, this is the right stage when you should go ahead and get a patent on your AI innovation. But before you do that, it is important to understand that what are the technical challenges and filing based challenges that we face specifically with regards to AI innovations. Now, so any novel methodology that you have devised uh, may be counted as an innovation, but every innovation might not be counted eligible for a patent. There are three key aspects that any innovation or AI innovation must have for it to qualify for going ahead for the down the roadmap of being converted into a patent. These three key aspects include novelty, which means that your product, process, methodology, it should be new as compared to what is already existing, as compared to the existing solutions to the problems that you are trying to solve. Then it should be non-obvious. Now, non-obvious is as such a very subjective term, but broadly it means that anybody who works in the same domain as you and who has technical skill which is equivalent to somebody like an inventor or somebody who's developing this AI innovation, they would not have been able to contemplate your invention without going through some serious technical challenges. So what it means is that it should not be that the invention that you have made sounds frivolous. So there should be some technical challenges and issues which you can show that you have overcome. Why your innovation should be taken down the road of getting a patent.
Right.
And the
So,
third,
Astha, I would quickly like to give an example here, just to make it clear for everyone. So, for
okay,
example, if someone conceived of a nut, a hexagonal nut, and some other person comes and he says, I have an octagonal nut, you could have easily conceived that, if you increase the size, the amount of pressure that would fall on the whole thing would reduce. So, and that was the purpose of a hexagonal nut. So, that would be considered as an obvious improvement, just for quickly citing an example here. Yeah, please go ahead.
sure. Thanks, Henry. And so that and the next aspect is utility or usefulness of your innovation. So in any jurisdiction, be it India or abroad, it is very important that your invention should have a practical utility or a practical use case which benefits from this innovation. So while I was also looking at some of the questions in the chat when the panelists were discussing, so one of the questions was that if your innovation does not have any market benefits, so can you still get it patented? So market benefits is one aspect, but utility is something which translates your innovation to some real world scenario. So even if it does not have some market benefits, but it has a utility, you can go ahead. And once you have identified that your innovation has at least these three aspects, you can walk down the road of getting it converted to a patent. But it is not very easy. Having the right balance of all these is very important to get a patent which satisfies, again, three criteria. It should be of high quality because the underlying reason of filing a patent is that you should have some privileges which are exclusive to you, and you should be able to reap the rewards of your innovation. So the patent should have that much quality that it can let you provide those benefits. It should be broad enough so that you can actually go ahead and determine if there are some competitors who are trying to copy your solutions or innovation. So you can go and go after them and uh, enforce your rights. And at the same time, the patent should be infringible. So infringible is actually the test by which you can say that some competitor's product or some process, it is overlapping with the technology that I have disclosed in my invention. So how easy it is to detect that measures the infringible aspect of a patent. So it is important to have a right balance of all these three if any one wants to really benefit from the patent and really reap the rewards of their innovation. Now, moving on, this entire part from innovation to getting a patent, it has three major stages. First of them is ideation and understanding. This phase is very important because this is where you start with your raw idea. And so when you have some idea, you conceptualize it, you document it. Then, if you are in an organization setup, or if you have access to some IP experts or some other experts, so you can brainstorm and distill it down to identify those aspects of your idea which would be really profitable for you, which would benefit and which would have a more likelihood of getting a grant. Now, this is again a process which can take place through a number of stages. But once that is done, and you have identified some high quality, invention disclosure, and that is generally done in the form of an IDF, then a prior art search, which is looking at what already exists in your innovation space, that is performed, and based on that and a comparative analysis, you further refine your scope and novelty. And these steps are generally performed iteratively until you get a very high value document representing your idea. Once that is done, and you have also done a comparative analysis of your innovation vis-a-vis what exists in the art, then you can move on to the next stage, which is of drafting. Now, again, if you take assistance of some experts, so they would ideally want to discuss and define the scope of your idea before going ahead. And then a patent application is drafted. And at that stage, the discussions that are held with you as inventor or firm, so they are very valuable because it is there that the legal scope or the boundaries of your protection are identified. And once an application is drafted, then finally the inventor can review it and get it finalized. And so that the next stage of official processes, which is filing and grant, begins. So once a patent application is prepared, then in the jurisdiction that you want to go ahead for protection, there are patent offices. You submit filing documents and requisite fees, the prescribed fees for the type of filing that you do. Then after that is done, your patent gets into the hands of the patent office and the examiners. Based on your request, they perform an early publication or a normal 18-month publication. And then further, if you request for examination, so that is examined. There, the patent office gives their view, whether they approve or disapprove of the utility, novelty, and the the innovation, and whether they decide to give it a grant or whether they refuse it. And generally, prosecution is the stage where a lot of patents get drawn. And we will look at the life cycle also of a patent in detail. But if you successfully navigate through that, then you get your innovation patented, and thereafter you pay renewal fee at stipulated time periods or every year. And then you can also think of getting monetary benefits out of it. There are numerous monetization strategies which can be then used for a granted patent. Now, I briefly touched upon the ideation and understanding phase. So, this is very important because, as the saying goes, that well begun is half done. So, if you are able to identify correct scope of your invention during this stage by iterative stages of documenting, brainstorming, and comparative analysis with the prior art, and then finally identifying the correct scope. So half of your battle is won because you know which areas you have to focus on in the rest of the stages. So once you are past that stage, you pass on the control to somebody for drafting your patent application. Now you could get in touch with some experts, or you could, if you have your firm provides this support, you could get it done through your in-house team. But because it is also legal matter as well as technical, so it is important that this stage is also done right. So, as the Patent Office defines that a patent is a statutory right, and by statutory means that it is done by law and it is a legal right, and it is granted for a limited period of time to the patentee. Generally, that limited period of time refers to the term of the patent, which is 20 years from the date of priority of that patent application, or from the earliest filing of a patent application. And during that limited period of time, the patentee has the exclusive rights of making, using, selling, and importing their patented product or a process for producing that product. Now, in order to get into this exclusive right, the first step is that you draft your patent application. And the patent application, as we also saw in some of the discussions during the fireside chat, that it's a techno-legal document. So it should be prepared with the help of some experts in the field, and in collaboration with multiple stakeholders like inventor, the R&D department if you have a big firm, or an in-house IP team and an IP expert. So it's a joint collaborative effort which converts your innovation to a patent application. Now, there are different parts of a patent application. Uh, Title just outlines the title of your invention. Then you have an abstract, which is a 150, a nearly 150 words summary or an overview of your invention. The detailed description of your invention comes in specifications, and specifications further have subfields, which include field or the technical field of your innovation. So, in international systems and in for search purposes, there are a number of classes, technical classes, which the examiners, the patent office, they use for identifying related art. So the technological field defines that aspect, that technical field where your invention lies. Then the next section is background or prior art, which we also briefly discussed when we were discussing about ideation. So here you, as inventor, in your words, describe what is the problem that you are trying to solve, and what are the existing problems, solutions that are there, and why they are not able to overcome the challenges, or why they face some challenges, and they still have scope for having a better solution implemented, which you would be later explaining in your description. But in background, only the challenge is outlined and the previous solutions. Then you have one or more figures, which pictorially represent the concepts of your invention. And then detailed description is the section where all the remaining pieces they fit together. You describe your figures, you give detailed explanation of your concept, and you add information about the real world scenarios. You disclose the best mode of performing your invention. So all that goes into detailed description. Now, these are more or less technical parts of your application. Now, the next part, which is very important, is claims. Now, claims are the legal aspect of your application. And probably there can be independent claims or dependent claims. So, independent claims can have, they cover the novel aspects, they include the novelty by themselves. So, at India Patent Office, you can file 10 claims for which no additional fee is charged, and there is no limit on the independent claims. But beyond that, some fee is charged per claim, which we will also look at later when we discuss the fee schedule. But by far, claims are the most important aspect for your patent application. Now, why are they most important? Because claims define the legal boundary within which you will be provided protection. They define the scope of your innovation, and they also give you the exclusivity over others in the field. So even if something is there, let's say in the detailed description section or in background or anywhere in the specification, abstract or title, but that is not covered by the scope of your claims, so you cannot be given legal protection or exclusivity on that content. That is why it is most important to have your claims drafted carefully, and it is at this stage that all your discussions, your ideation discussions, brainstorming sessions, they help, the prior art analysis helps. So keeping all that in mind, the claims need to be drafted. Now, the scope of the claim has to be identified very carefully, because if it is too narrow, that is also a problem. If it is too broad, that is also a challenge. So it has to lie somewhere in between. Now, why? Because if you have a very broad claim, then that may actually lie in public domain and may overlap with some of the prior solutions that you have seen, some of the prior, and thus it may not be considered novel. And if it is too narrow, then maybe let's say you are just focusing on what you are doing in your product and you are focusing it on too much details, then it may be too difficult for you to prove infringement from your potential threats in future, or it may be too easy for them to work around your narrowly limited claim and still devise the same solution, still do the same thing that you are doing, but because you drafted your claims in such narrow interpretation, they are able to work around. So it becomes very important to have the claims drafted with the correct scope. Now, in respect of the AI innovations, we have some very peculiar challenges, specifically when it comes to claim drafting. So we discussed that any AI innovation is a combination of a training, a model, and application. But if we use the correct combination, which is that it covers the training aspect, application, and model aspect, then we may be able to prove that we have a novel, eligible, and infringible claim or an application. But if we choose any of the wrong combinations, like let's say that we just choose to protect our model, so it may be novel, but because models are generally complex mathematical expressions, calculations, and statistics, so the patent office may reject them as ineligible subject matter. Similarly, if you try to go and protect only the training part, which maybe you think that you have devised a novel training methodology. So it might be novel, and because of the interaction of this training system with real world elements, it might even be patent eligible. But because it happens offline, it might be difficult to detect. For example, if a company uses your training methodology and implements it in their model and then develops a product, so ideally they are just doing the model application. They would not be infringing on your innovation because the training was actually done offline separately and they did not disclose it. Similarly, when it comes to only application, so that is also generally not considered novel. This application could be something like controlling a robotic arm. So this generally only applications are too broad to patent. And now let's say some combinations. Let's say you try to protect training plus model. And if a company A is doing training, but the model is implemented by some company B, so this gives rise to issue infringement issues like divided infringement. Now, what this means is that let's say you have protected training methodology as well as the model in your claim. So, in order to implement all the steps of your claim, both company A and company B, they have to perform jointly. Only then they would be able to implement all the steps. So when you go for litigation, you would have to file a lawsuit against both of these companies. This generally is a major challenge later. So generally, this such combinations also should be avoided. And similarly, if you have just model and utility, so again, it could be narrow because you're saying that you are using your model for a specific application. So that may be too narrow or difficult to easy to work around for your competitors. And another interesting combination is training and utility. So if you try to protect your training phase and your utility, so it would be ideally very broad because Maybe the actual model is nowhere in the picture. So because of all these aspects, it becomes very challenging to draft AI patterns with correct scope. And these are the technical challenges that we face. There are some filing based challenges also. So we know that in earlier, at least till 2017, all of the applications that were filed for AI, so they were considered as software patents, and there were no defined guidelines. They were not well defined, because of which a lot of them were rejected because of having patent ineligible subject matter. Then in 2017, computer related inventions were specifically assigned guidelines, and AI innovations now fall into the category of CRIs. And CRIs also define, right now they are not very well defined. They give you some of the strategies which you can use, like some of the allowable matter that they have started allowing in your inventions and specifically software patents, but still they are not that well defined. Specifically, if we compare them with global jurisdictions, like if I talk about USPTO, the US Patent and Trademark Office, so they regularly publish some examples which give examples of granted patents or frameworks. Like for AI, also they release examples of claims which can be used. But right now, we are still to catch up with that level. And as a result, under Section 3K of Indian Patent Law, most of the AI innovations get rejected as being directed to a mathematical or business method or a computer program or algorithm, which is generally what we envisage AI applications or AI innovations to be. And just because of this, there is also a little bit paucity of good reference literature and landmark cases. But still, Indian patent system is still evolving and it is adapting. And maybe in future we would have more robust framework. But right now we are still in an evolving stage. Then what should we do? Now we see that we have technical challenges, we have filing based challenges. Then what should a practitioner or an inventor do? So first thing is that you should focus on your core competencies, because you need to have a very guided focus area, a very you need to have a very specific direction that you need to follow. You need to identify where your competence and where your novelty lies. Are you a company, an inventor, or any firm who is focused on developing training methodologies, or are you developing models, or are you using them? So you have to very strategically, delve into this field and identify your competencies at the beginning of your ideation and patenting process itself, so that your priorities remain clear. And then you can further take the help of experts. So these experts could be, as what was also discussed in fireside chat, they could be some facilitators, they could be IP firms, they could be attorneys. But it is important to have their opinion, so that you are actually able to leverage the benefits of your innovation, and your innovation does not get rejected just because you did not take the right guidance at the right time. And from the practitioner's perspective, it is very important to define these two features: technical effect of your invention and technical advantages. Now, technical effect by interpretation means that an outcome or effect that your innovation produces in the real world. So it could be in the terms of, if you are using your ME model to power an actuator, or you are using some inputs from a medical database, and then you are feeding it into a model, and then you are again using it to do analysis of patient data and provide them tele advice or tele consultancy. So actually, you are tied at every stage with some real world objects or entities. So there is clearly a technical effect that your invention is producing. And second important aspect is technical advantage. So technical advantage again could be in the form of how computationally efficient the methodology that you have devised is. Is it also able to provide some economic way of implementing any processing operations? Is it able to save on some memory? Is it able to perform faster? So all these types of technical advantages, and as many as you can think of, it is imperative to clearly define them and put them down in your application, because this in the end becomes the subject matter on which a practitioner will rely to take your idea forward for grant. So, in order to do that, your specification and the description, it should have sufficient support of everything that your innovation is related to. So, even if you are focused on a model, you should include details of training methodology and the best mode and practical application of your invention. And once that is done, in from the claims perspective also, you need to tie your invention to some suitable hardware elements. And so by in plain language, generally when people draft claims which mention computer program product, so now patent office has become vigilant and only citing this does not help. We have to tie some suitable hardware elements or some tangible elements from the real world that your model based innovation is effective and it is implemented through those. Such hardware elements have to be identified throughout your specification, and specifically in the claims they need to be mentioned so that your invention does not fall into the category of patent ineligible subject matter. If all of these practical tips are taken care of, then it increases the likelihood of getting a grant on your patent much more. This is the next stage that we had, that how what are the processes that you do for filing. So you can either file a provisional or complete specification, and based on that, your if you don't file a complete application after provisional, your application might get abandoned. But if you do that, the next stage is that your application goes for an examination with the patent office when you file a request for examination. If it is not filed, again the application gets abandoned. But if you do, then the patent office issues their opinion in the form of a first examination report. You respond to FAR with your opinions, and either it could be accepted by the patent office and eventually you get a grant, or it might not be accepted and you might get into a hearing session with the examiner where you try to explain the strategy and novelty of your innovation. Again, based on the outcome, whether the examiner is convinced or not, you get a grant or your patent goes for a refusal. These are some of the official fee that we have tried to highlight, and they vary for e-filing and physical filing, and they also vary for the type of entity who is filing an application, whether you are a individual and a startup, a small entity, or others. And details of these can be obtained from IP India website's detailed fee schedule page, for which we have provided a link here. And yeah, this is very important. Government of India has actually launched several initiatives for startups and MSMEs, and just to promote awareness of IP and also to establish transparency. So, like a cell for IPR promotion and management has been set up to provide awareness about IP material and IPR, and with specifically curated contents for the type of institution. Then there is a mobile app and e-learning platform L2 Pro, which again has the intent of spreading awareness regarding IPR. There is a very important patent facilitation program. As part of this, at state level, 24 patent information centers have been implemented in various states, and they have further led to establishment of 84 intellectual property cells in universities. So they cater to inventors from government organizations and state universities and provide assistance to them in getting their ideas patented and filed. Another important achievement is that the Indian Patent Office and Japanese Patent Office (JPO) they have entered into a bilateral agreement called Patent Prosecution Highway, as part of which both of these jurisdictions can leverage expedited examination of their applications. And currently, there is a limit of 100 applications per year, which can be examined under this program. Then there are several technology and innovation support centers, which the World Intellectual Property Organization, in collaboration with DPIIT, the Department for Promotion of Industry and Internal Trade, has set up. And they plan to provide IP services like technical resources, databases, and even strategic information. Then several other schemes that are available for startups and MSMEs are that they are eligible for 80% fee rebate in their official fee that is related to filing and all the later stages as compared to large companies. Then for startups, there is a provision to get their examination, patent examination and application expedited. And this is very important if you want to get ahead of competition. Then in 2016, the SIPP scheme, the Startups Intellectual Property Protection Scheme, was launched, which Henry also discussed briefly in the fireside chat, as part of which 289 patent agents, and the list is also getting updated, have been empaneled. They are facilitators for startups, and they provide assistance in preparing, filing, prosecuting their patent applications, and all the fee of the facilitators is borne by government. Then specifically for ICTE sector, there is this SIP EIT scheme where financial support is provided for international patent filing in this sector, and a maximum reimbursement of up to 15 lakh per invention or 50% of the expenses which are incurred in filing such an international patent, whichever is less, that is provided. And currently, only one application can be filed with this scheme. And another very good initiative is building awareness on intellectual property. So, some of the salient features of this building awareness scheme are that there can be a financial support of up to INR 1 lakh for organizing awareness or sensitization programs. There can be a support of up to 2.5 lakh per pilot study to identify IP needs of MSME clusters, industries, and expert agencies. Then there can be a financial support of up to INR 2 lakh for organizing interactive seminars or workshops. And there's a financial support of up to INR 6 lakh for organizing short-term training programs and 45 lakh lump sum for organizing long-term training programs. There is a financial support of 1 lakh on grant of a domestic patent and 5 lakhs on grant of a foreign patent. Again, there is a support of 1 lakh for registering a GI or geographical indication, which is another form of intellectual property, and 65 lakh for setting up of IP facilitation center. The more details are available on this link, which is provided, and which we can also share this later in an open forum. But all of these initiatives are aimed at assisting all the startups and inventors and promoting this culture of awareness. These are some of the important resources that we have provided. You can have information of these resources available uh, after this session. There are guidelines, there is search tool of patent office, there are form entry details, there is a manual of procedures how the patent office operates. Then there's a utility for e-filing of your patents. Then the startups protection scheme, that details can be accessed here. And then list of facilitators can also be accessed. Then there's a startup recognition form which you need to fill for availing some of these benefits. So I think with that, I have come to the end of my session, and we have uh, we have tried to answer some of the questions that we initiated, like can we get a patent for software, or if you accidentally disclose your product, so you can still file a patent within a grace period of 1 year. And if you are developing a novel training methodology, but still you tie it to your hardware, you can still get a patent. So all this we have tried to address.
This was very helpful, Asta. Thanks a lot. And I think I would like to pass it back to Neha to thank everyone, for this session. And in fact, the last, yeah, these couple slides, these were really interesting and very helpful. I'm sure for the audience, and they can go offline and take a look at all of these links and how they can avail these, incentives. Back to you, Neha.
Thanks, Vaibhav, and thanks, Aastha, for such insightful details that people now can really refer back to in terms of filing their AI patents. And for the benefit of the audience, we'll share the complete recording soon, and keep following India AI and NASCOM Research Twitter handle, so you'll get to know when the recording is up. And before we close the session, I would just like to thank everybody who attended. the session, our speakers, Anand, Gagandeep, Vaibhav, Aastha, for taking their time out. And it was really an insightful session, and we look forward to more such sessions going forward. And I hope everybody stays safe, and do read the report. We'll be looking forward to your suggestions. We'll also try to answer most of the questions, and we'll follow up that with a tweet chat. So stay tuned on the Twitter handles, and we'll let you know what next. Thank you.